Garu. Rahul Garu, thank you so much for being on the show today, Andy.
Thanks for inviting me there.
All right, folks who are watching, call our expert on 1-833-882-8872. The number again is 1-833-882-8872. Watch us now on TV9, Yup TV on TV9, Facebook on TV9, YouTube on TV9. You get the hint. So Sling TV, World BB TV, and Dish Network all on TV9, please. And let's come to our topic for today, which is the fiscal year 2025 and the H-1B visa cap. We love this part, Rahul Garu, as we've always done, is the predictions and, of course, some of the strategies that we need to apply for this. So we'll come to your favorite part first, which is the predictions, Andy. So let's see what the parrot has to say this time, not the metaphorical parrot.
It's expected that it's expected between 400,000 to about 500,000 applicants are going to be applying this year. So the chances probability for the master's quota seems to be a little bit higher than last time. Of course, the bachelor's quota is also a little bit higher than last time because last time 700,000 people that applied. Of course, but last time what happened was that there were a lot of duplicate applications.
Correct.
And USCI has found out approximately 400,000 duplicate applications were there last time. But this time, there is not going to be any duplicate applications, at least to the best that we can think about. I don't know if they can, this fraudster can come up with some fraud. Because it's going to be based on the employee. So for example, if one employee is going to file with 5 different consulting companies, let's say Rahul Reddy is going to have and his date of birth is so and his passport number is so. If he files with 10 companies, they will consider Rahul Reddy as only one person based on the passport number, my name. Now, once that's considered, if I get selected in that lottery though, then I get to choose which company can file a H-1B though. So it's not going to be like previously where I will be counted 10 Rahul Reddys, will be only one Rahul Reddy, even if somebody files for 10 applications. And that is also discouraging for a lot of people not to file any duplicate applications. So it's expected to be about 500,000. That's what we're expecting. And master's quota will definitely have a higher chance because the way they do it is that first they do the batch that includes everybody, and whatever is left over will go to the master's quota again. So expected to have a lot of people who are going to be selected in the master's quota than last year. Yeah.
Okay. And Rahul Garu, this same rule applies even for when you're, like you say, right? Say you've applied to Pepsi and Coca-Cola, and both of them are trying to put in an H1 for you. At that point, it will still be considered as one applicant, right?
That's right. It will be only one applicant. It will not be 2 applications.
Okay.
And Nitya Garu, the quota was supposed to be over on 22nd though, which is a Friday, but they did postpone to Monday at 12 noon. So anybody who they can stop apply until Monday at 12 noon. Most probably the selection process will start somewhere in April first week, which we're expecting either on March 29th, 30th, or probably on maybe in April 1st, 2nd. That's the time that we're expecting them to select the lottery. That's when we start getting the emails to the lawyer, hey, you got selected to the company. We'll get the email that you got selected.
Got it. Okay. And again, what are some of the strategies, Andy, that you're thinking of at this point?
Right now, one thing, of course, you get selected in the lottery, you have to file the H-1B. You have until June 30th to file the H-1B. I strongly recommend don't wait until June 30th, file, as early as possible. You don't have to file in April 1st week, but you can file somewhere sooner, but don't wait until the last week to file the applications. There'll be a lot of rush at that point of time. And those people who are eligible for the cap, that means that if their OPT or STEM extension is expiring between April of 2024 to October of 2024, make sure that the H-1B is being filed before your STEM extension or OPT expires. In that way, you will have the cap available for you. That means that once the H-1B filed with a change of status, not the consular processing, with a change of status, they can continue working after their OPT and STEM extension expires. but it has to be before your OPT or STEM extension expires. Don't wait. Let's say, for example, your STEM extension is expiring on May 1st, though. Can you file on June 15th? You can, but the problem is that's the cap. That means that you cannot continue after your STEM extension or OPT expires. So try to file it before the STEM extension or OPT expiration. Another thing to note is that there are some companies that are trying to file H-1Bs not in the consular processing, but they're trying to file the H-1Bs, they're not in the change of status, but they're trying to file in consular processing material. So that's a very wrong idea to file the application in the consular processing when the person is in the United States, because they're trying to say, okay, you have a STEM extension for the next 2 years. Let's save some money on the taxes. Let me file you in the consular processing. You can always go to India and get the stamping. Don't fall into that trap. Do not fall into that trap. File the change of status. Please, you do not understand the consequences of it. The reason is that if you file in the consular processing, technically you're not counted toward the H-1B number. You'll be only counted to the H-1B number when you either get the H-1B stamping or when you get the passport stamp, though. Here, you are neither getting the H-1B with the I-94 change of status or the passport stamping. You're technically not counted. So tomorrow, if you lose the job, though, within the time period of the H-1B, you want to move to a different company, you cannot move on the H-1B. So if you are here in the United States, go for the change of status, not for the consular processing. Now, there are some people who wants to get the H-1B, but they don't want to be an H-1B. I still recommend them for them to file a change of status. They may say, no, if I file the change of status on October 1st, I'll be an H-1B. I want to maintain the H-4 EAD and all those things. Yes, you can do it, though. You can do it. The reason why you can do it is that you can get a H-1B with October 1st start date. On October 1st, you fly to Mexico and come back on H-4. In that way, on October 1st, you are an H-1B. That means you're with the I-94. That means that you're technically counted toward H-1B. Then on October 1st, you went to Mexico. You had a Margarita, and then you come back. And then you are on October 2nd, then you are October 1st or October 2nd, you are an H-4. And people may ask a question, oh, I don't have my H-4 stamping in the passport. No, you don't need. It's called automatic revalidation. As long as the H-4 I-94 is still valid, you're still married with the same person who is on H-1B and he's still working for the company. All you come and shows a H-1B with I-797, you're good to go. Absolutely no problem. So L1 people also do this mistake of not filing consular processing. Don't do it. File the H-1B in consular in the change of status. Once you get the approval, you can do this Margarita switch by going out to Mexico and coming back.
Okay. And folks who are watching, when in doubt, just call us with your question. So we can always help you on the spot at that time right away in terms of answering. If you still have that 1% doubt about whether I should do consular processing or not, just please give us a call. Do not hesitate to do that. All right. Thank you for that, Rahul Garu. Anything else you'd like to add at this point, sir?
No, we can go to questions today.
Okay. And before we go to the questions, has there been any update on the trade talks, Rahul Garu?
No, not much on the trade tax. So, but these are the things that normally happen secretly within there. They don't go to public announcements. They don't have a lot of public debate because this is an agreement between two executives, so which may not require any legislative action. For example, a trade treaty between India and United States does not need the entire Congress approval, though. The same thing is true in India too. So these are very secretive talks that happen. So most probably we may get something, but nothing publicized yet, other than the Forbes magazine publishing. Not much. I haven't seen any major news organization that is publishing on the trade talks between United States and India.
Okay, got it. Thank you so much, sir. Okay, on that note, let's take our first caller for the day.
It's publishing on the trade talks between
Okay, caller
United
number
States and
ending
India.
in 1987, 1987. We're ready for you now. Hello?
Hey, hi, Rahul. Hi, Nitya. Can you
Hi,
hear me?
sir. Yes, sir. Thank you for calling
Hi,
us. Welcome to our show. Please
Yeah.
tell us your question, sir.
Sure.
Go ahead.
Yeah, good evening, both of you. Yeah, so my question is actually my cousin from India is in US on B2 visa,
Mhm.
and while being here, he has actually applied for a couple of colleges, and he did get an admit for one of the college.
Mhm.
So we are thinking to do a change of status while being in USA from B2 to F1, or
Mhm.
if not, then maybe we are planning to go to Mexico. So Rahulji, what do you suggest? What should be the steps we should keep in mind while going for the visa interview, or anything which we should consider?
Which university and what is the course that he's attending?
Oh yeah, actually, so the university is in New Jersey. That's the
What's
St.
the name?
Peter's, and the
Okay.
course is he is from medical background, so it's mostly related to medical course, masters in healthcare.
I would recommend him to change the status within United States. He can apply for an I-539 application. He can file it online. He can do it manually. He can file an I-539 application where he can apply for the change of status from B2 to H1. And there is a premium processing that he can use. In that way, he doesn't have to wait for a long period of time to get the approval. So if he goes to Mexico, there is about, 50% risk that he may not come back, because he has to prove that after completing his education, he's going to go to his home country. Sometimes that becomes tough when people come here on B2 and then they go to Mexico and get their stamping. I would suggest strongly to go to the to go to the change of status and file within United States.
Okay, and Rahulji, one more question, follow-up question. So let's say, in case we had to go to Mexico, so let's say if there is a denial, for change of status, but he has still the B2 visa, so will he be still able to come back in US?
There will be a good chance that they may even cancel the B2, because if they found it that his intention is not to come into United States temporarily, they can always cancel the B2. Very high likelihood that the B2 will be cancelled. But if the B2 visa is not cancelled, he can come back. Otherwise, if the B2 is cancelled, he cannot come back. If it's not cancelled, he can come back. Okay.
Okay, and sorry, one more final question, Rahulji. So let's say, once we do that change of status being in USA, so and that too in premium, so then when do we he goes for the stamping, after the completion or before completion, while pursuing his
He can
master's?
think about any time going before completion, of course, not after completion. He can go for stamping later on. Okay, we'll go to the next caller. Aunty.
Okay, sure. Thank you. Thanks a lot.
Thank you.
Thank you, sir. Thank you so much for calling us. Rahul Garawan, I'd like to take a couple of quick questions, Andy, that's coming in on the live chat as well.
Okay.
Question from Raj. He says, renewed my EB3, EAD and advanced parole, got the 5-year combo card, but it shows the wrong priority date on the 765 approval notice. It shows the receipt date as the priority date.
He can ignore the priority date that is there on the combo card, which is approved for 5 years. He can ignore it. He doesn't need to go and request them to change the priority date. He's good.
So what? Okay.
He should do nothing. His EAD is still valid. His advance parole is still valid. His priority date is as it is in the I-140 approval. He doesn't have to go and request them to change the EAD card. If he does request them to change the EAD card, he has to send the EAD card, and that they are never going to change it. They're going to take it. Then they will be na garka, na gatka.
And they never lived happily ever after. All right. Let's take our next caller. Okay, caller with number ending in 3921. 3921, we're ready for you now? Hello? Caller with number ending in 3921. We're ready for you?
Hi, good afternoon, Nitya Garu and Rahul. Can you hear me?
Hi, sir. Yes, we can hear you, sir. Thank you for calling us. Go ahead with your question, sir.
Yeah, I have a scenario that I would like your guidance. My H1 is valid till 29 December and same as my wife's H4. Recently, I got my I-140 approved. So I want to understand what is the best way to pursue the H4 EAD. I saw your previous videos, Rahul Garu, and one of the things that you advised is you can go with H1 and H4 extension and club that with EAD application, so which I will try with my employer. But I'm not sure if it's going to accept because EAD is my personal thing, so I'll try. In case if they say they will not, I want to understand what is my best next step. Yeah.
Typically, most of the companies, I would say about 95% of the companies will say okay to file the EAD along with your along with the H-1B. They will file H-4 plus EAD. So if it is expiring in December, though, you can file the H-1 and H-4 and EAD together in June of 2024, which is about 3 months. But you can do one thing. You can file an amendment plus extension. This only 20% of the companies will accept it. So that can be filed. Amendment plus extension can be filed in March of 2025. All the way to you can file all the way to March of 24 to all the way to 2027. That is one thing that you can do. The second thing that if they are not going to do amendment plus extension, file the H-4 plus EAD right now. I'm sorry, just EAD right now. She's on H-4 right now. File just EAD right now. And at the time when you file the H-1, add H-1, H-4 and EAD together. Even though she has the EAD application pending, she can still file one more EAD application along with the H-4 application.
Okay, I think that helps for the clarification. And one last thing, in case my employer says, okay, I can club application, but I may need help in creating the EAD package. Can I engage your firm?
Sure. You can. Most of the companies won't require, but yeah, if they ask you, we can just give all the application. They can just include it along with the application and send it to USCIS. Yes, we can do that. Anybody can do it. Okay. Thank you.
Okay. Thank you very much for the clarification. Have a good day.
Thank you, sir. Thank you so much for calling us. Rahul, there a quick question, and a lot of people are wondering about these H1 extensions and even subsequently ththese H4 and H4 EAD extensions and stuff. Apparently, some people have been facing, been on hold for a long time. Some even 6 months plus. Is that a general trend, or
it's taking almost 6 months to get the H1 and H4 and EAD approval, though. Of course, there is a premium processing that's available, and that's the cost of the premium processing also going up on April 1st. So yeah, it may be worth for you to do premium processing, though. Couple of reasons. One, the H4 EAD discontinuation of H4 EAD is not good. Discontinuation of the H4 EAD is not good. The second aspect is that I always like to get the result before the H1 expires. So let's say the H1 is expiring in June of 2024. We are filing an H1 extension. I would like to get the result before June of 2024. Let's say you do not file a premium processing. In July of 2024, we get the RFE and then we get the denial. Then the person has to go to India and get the stamping and come back after filing one more H-1B. But if we file and get the result, if we do the premium processing in March right now and get the result by June of 2024, if the denial comes in, you can refile the H-1B application. In that way, the person doesn't have to leave the country, though. So definitely try to get the result before your I-94 expires. That is a better way.
True. And so for those people who are waiting, their I-94 is expired and they're still waiting for a response, are they still technically allowed to work, sir?
Absolutely. They're allowed to work. They're definitely allowed to work, though. Now, if it's an extension, though, they're allowed to work only up to 240 days, though. If it's a change of employer, though, there is no 240 days they can work. That means that if the I-94 expires in June 2024, they can work up to 240 days, which is, I don't know, December, then you add up about 3 months, January, February, March of 2025. So by that time, definitely they'll get a result.
Okay. Got it. Okay. Thank you, sir. Thank you so much for that clarification. Let's take our next caller. Okay, caller with number ending 4177. 4177, we're ready for you. Hello? Hello? Caller with number ending in 4177, we're ready for you.
Hello?
Hello, sir?
Hello, can you hear me?
Yes, sir, we can hear you, sir. Thank you for calling us. Go ahead with your question, sir.
Rahul Garu, I applied for H-1B amendment because of a change of client, and it is still in premium processing, and the lawyer said, like, my wife can go for H4 EAD stamping with receipt number. So she did that, but she got a 221G saying that we can't approve your H4 EAD or H4 because your husband's status is still pending. It has to get approved, and he can either send his approval letter or the stamping document, like scan document, by email. Like she can send it and she will get the approval. Is that normal?
It was definitely not a good idea to send your wife while the amendment is pending. Not a good idea at all. When one department, the application is pending, you're telling the other department to approve. That approval is based on this application. Never send when it's in pending. You should have had that one approved. Now, my first question to you is that, do you want your wife to come to United States faster or later?
Faster.
Thank you. Do the premium processing, get the H-1B amendment approved, and then send the approval to them.
Yes, I already upgraded it, and they said to her that you don't need to come for interview again. Just like if you can send the scan documents by email, and if you drop off the passport, we can give you the stamping.
Sounds good. So,
so everything is normal.
Then, you know what to do. Yeah, that's normal. That's normal. Getting a 221G was completely normal. I would have avoided it though. Had you come to our show, we would have avoided it. Okay?
Yeah, it's actually because if it's a company lawyer, we don't know if we need a second opinion or a third opinion sometimes. So.
Yeah, sure. Okay then. Thank you. We'll go to the next person.
Thank you, sir. Thank you so much for calling us. And before we take our next caller, question for you, Rahul Garu. This is from Venkata Akkepati. Says, after H4 and H4 EAD approval, if I want to go back to H-1B again with my old employer, can I go to Canada, and while entering, can I show my old H-1B to CBP and get a new I-94 on that H-1? Does that work?
Margarita switch is what he's speaking about. Where can he go to Mexico or Canada? Technically, he can though. Technically, he can. Because if the H-1B has not been withdrawn though, it's still active. So he can activate it by going to Mexico or Canada and coming back with the automatic revalidation. However, a couple of caveats in this, Nitya. One thing is that because if you're coming back and you, they will check into whether your job still exists with that company. You're on H4 plus EAD for a while. Did you continue working for the same company or did you switch to another company? If you switch to another company, when you're going back to the old company, is it the same end client? Is it not the same end client? So if the end client is the same and you have been continuously working on H4 plus EAD, I definitely don't see any problem at all, none whatsoever at all for you to come back on the H-1B. But if you have switched from company A to company B on H4 EAD, and you're wanting to switch back to company A, you may be questioned very thoroughly whether you still have a genuine job opportunity with company A, whether you're still meeting the LCA requirement, whether you're going to work at the same location. But if all those things are meeting, all the dots are ticked properly, I don't see any problem for him to go to do the automatic revalidation. Also, what Unitech invented your name as Margarita switch, they can.
So for the Canadian one, should we call it like the maple syrup switch ending?
Yeah, we can.
All right. Rahul Garu, thank you so much for that. I am going to take our next caller. Don't mind. Yes. Okay. Caller with number ending in 6650. 6650, we're ready for you now?
Hello, Andy. Hello, Nitya Garu, Rahul Garu.
Hi,
my name is Krishna.
Go ahead, sir.
So currently I'm on H-1B, Andy. I got my EB-1A I-140 approval 3 weeks back, and I filed my 485 last week. A couple of questions, Andy. So I have a child, 10 years old. So when does her age get logged? Is it on filing or on approval of EAD or AP or something? The second question is, this is a self-petition. So
let me answer the first question.
During this.
Let me answer the first question though. So you filed your 485 in March of 2024. By March of 2024, you have an I-140 approval. The priority date was current. You
Yes.
filed 485 and your child was under 21. So all 4 conditions have been met. So the child is locked for the Child Service Protection Act purposes. Go ahead with the second question.
Okay. So the second question is, this is a self-petition, EB1A, that I got
Of course.
approval.
Mhm.
So if I lose a job during this like 1 year before I get my green card, will there be any impact on my 485?
Okay, technically your green card, unlike the EB1B, EB1C, EB2 or EB3, they are all dependent on the employer. EB1A, and there's also national interest waiver. These 2 are technically not dependent or linked with any employer. They have been given to you because of your worth or your extraordinary ability in your particular case, your extraordinary ability. So just because you lose the job with company A while you're working and you file the 485, technically you're not ineligible for getting the green card. However, I just want to be a little bit more cautious though, because you still need to show that you still have the capacity to maintain the job in United States in that particular EB1A criteria. So I still want you to have another job in a similar profession with a different company if you can get it. If not, there are some other technical ways where you can be self-employed, or maybe your wife here can employ you. Those are other ways that you can do, which I would like you to contact the lawyer if it happens to you, okay? If you don't happen to get a job. Those are technical ways to keep your green card alive, okay?
Okay, sir. Thank you. That's all I have. Thank you so much.
Thank you, sir. Thank you so much for calling us.
Nitya Garu,
Yes.
Nitya, I'm seeing a trend recently in the past couple of years. E1A approval is going on. The approval ratings have gone significantly higher for a lot of people. So maybe people who are on the marginal things. Now, there are 10 criteria for the EB1A. People should try to meet at least 3 to get the green card though. People should try to evaluate, go watch those, YouTube or those 10 things, try to see if you can marginally meet for any of those 3 criteria, and then see if you would like to try for EB1A. Now, a lot of people ask the question that if we try to file a EB1A, if you get the denial, will it affect the EB2 application that's already pending? No. Will it affect the H-1B? No, it won't affect H-1B. It won't affect the EB2. So you may lose some money that you paid to the immigration lawyer or all those things. But if you're marginally eligible, you should try to move to EB1. Because if you're going to stay in EB2, in EB3, God knows when you're going to get the green card, especially for those people whose priority date is 2016 or 2017, it may take ever for them to get the green card. So they may, if they are marginally eligible, should try to get into EB1A category, like the gentleman who did it. We'll go to the next person.
Okay, sir. And one more thing about the gentleman who called about going to Canada and stuff. Do you recommend that someone like him actually talk to an attorney first? Make sure his paperwork and everything is sorted before he tries to do this Margarita switch.
The Margaritas, yeah. The person who's wanting to move to H4 to H1B by going H4 to H1B Canada though. If he's continuously working for the same company though, I don't see any reason for him to consult a lawyer. He can just go and get it done. If there was an interruption in the job though, I definitely want him to consult with a lawyer though. But continuously working the same company, I don't see any problem with it.
Okay, perfect. Thank you so much for letting me know. And on that note, let's take our next caller. Okay, caller with number ending in 1458. 1458, we're ready for you. Please press *6 to unmute your line. *6 to unmute your line, and caller with number ending in 1458. Hello? Hello?
Hello.
Hi, sir.
Nitya, are you able to hear me?
Yes, sir, we can hear you, sir. Thank you so much for calling us. Go ahead with your question.
Good afternoon, Rahul and Nitya. Thanks for your help to the people. And Rahul, I have a question, Rahul, actually. So I have my H-1B until 2025 in the month of October 20th. But my wife H4 and H4EAD and my boy H4 is going to expire this year. That is on 2024, September 15th. But we are planning to go to India. And I spoke with my attorney. Attorney said that, when are you coming back? I said, we are going on June and we will come back on July. He said that, don't worry, you go ahead and you come back. Once you will come back, we will apply both H4 and H4. We don't need to apply for H4s because they will use your I-797 to attend a visa interview in Hyderabad consulate, and your boy and your wife will get their H4 extended until 2025 in the month of October 20th. But coming back to the H4 EAD, he asked me, wait until come back. If we apply now, if you guys fly, there is a chance of rejection or getting an RFC from USCIS. So I need your help on this, Rahul.
So if you apply for the extension right now, you definitely can file the extension right now. But I like the idea of not filing, doing all that expenditure, because anyway, if you're going in June of 2024, when you go there, your wife and your child do not need any H4 approval. They can take your H-1B approval and come back into the United States. And coming to the H-4 EAD of your wife, though, since when they come into United States, they're going to get an I-94 until 2025 October. And when they come into United States, she can file the extension once she comes back in June of 2024. When she files an extension, we know that the EAD extension will not come by September. And your lawyer knew that EAD extension does not come by September of 2024 because it's taking about 4 to 6 months. However, though, since your wife has an I-94 extension done until 2025, and she is filing for an EAD extension, she is eligible to work for 180 days after the expiration of the EAD, which is September of 2024. So which will be somewhere in March of 2025 by the time the EAD is approved. So I completely agree with your lawyer's advice to you to do what he told and what we discussed.
Yes, sure. Yeah. Thank you so much, Rahul. This is what my question actually. Thanks for your help.
Sure.
Thanks, Nitya. Thanks for your time and have a good day.
Thank you, sir.
Bye.
Thank you so much for calling us. Appreciate it.
He's
Rahul,
trying
I
to,
have another
the lawyer
question.
is trying to save some money to the company, to him, and all the pain. Nice lawyer. Go ahead, Nitya.
All right. Another question from one of our live chat viewers. This is from Suresh Kumar. Says, previous year, H-1B that was filed got revoked after the visa interview at Hyderabad consulate due to a client letter. Apparently, the client is the brother of the employer. Does it affect current year filing?
Let me explain, Nitya, what exactly is the problem here going on with a lot of people. And this is a very good question that came in. A lot of people are asking this question this year, though.
Right.
So we have to notice a lot of H-1B revocations for fraudulently filing H-1Bs, especially those people who are not working for the company, especially those people who are in India, especially those people who paid money to file the H-1B, especially when those people who have companies that have filed the multiple H-1B applications, especially for the companies that file internal project when there is no internal projects, especially for those people who fake the end client letter, like probably this guy's employer got an end client letter saying that his brother is going to create his brother's company is going to give an end client job. So these are all the H-1Bs that get revoked, though. In cases where they get revoked for fraudulent or multiple filings of H-1B, technically speaking, they are never counted toward the H-1B number. So that means that if they want to file or if they want to be employed by any other company, their H-1B will have to go to the lottery system. So he is now telling that, hey, I already got my H-1B revoked for fraudulent purposes. That means I'm technically not counted towards H-1B. Can I now file an H-1B with company B and get the approval? Will previous H-1B revocation cause any problem? Well, first thing, Suresh, is that you should file in the lottery, that's for sure. Will previous revocation may cause some problem? Yes, they may look into it. They may look into it why previously this company's H-1B got revoked. Does this guy has a propensity to go through the fraudulent companies? So definitely it will be there. They will look into it. As long as the company B, which is filing the H-1B, is a genuine H-1B company, and is filing a genuine H-1B, it should, we should be fine. But otherwise, it still is going to be the same problem what happened last year. It will be looked into. They are going to scrutinize much more, but Suresh doesn't have much options right now.
Okay. Got it. So just, Suresh, if you're watching this, just make sure it's a genuine company with a genuine client, even if they're related, some plausible truth should be there towards it, I guess, right, Rahul Garu? Is that correct? Yeah. Okay. All right. And on that note, let's take our next caller. Okay, caller with number ending in 0955. 0955, we're ready for you now. Hello?
Hello, Niti Garu. Hi,
Yes,
Rahul Garu.
Hi, sir. Thank you for calling us.
Thanks for taking my call. I have a question on my aged out child. When I got the GC, I applied for him for I-130 on F-2B. And then I'm getting citizenship. Once still 130 is pending, not yet approved. Meantime, like once I get the citizenship, can I apply for F2A?
F2A. So once you get the citizenship, it's not F2A. It's the first preference, though. Yes, you can apply for the first preference, and the priority date of F2B.
F1A. I mean F1A, right?
Right. F1 category. Yeah, first preference, not F2 though. So the priority date of F2B will be converted into F1 category.
Oh,
okay.
Okay.
It's they're going to port it
automatically converts, Rahul Garu?
We should request that. We should request
that. Oh, we should request it.
So
that means another I-130 application?
That's right. You will have another I-130 application, and you will have another I-130 application, and your date will be ported to the first preference category. Okay?
Oh, okay. So, meantime, if he has his own employer want to apply for a process green card, so is that okay, or we are more confusing them?
Oh, absolutely not. We are not confusing them. That is a different process.
Oh, okay.
He's saying that this is my dad, and he's saying that Coca-Cola is the company that I want to work, is not at all conflicting at all. Go ahead and do it, though.
Okay.
So what is the priority date for you in F2B category, though?
F2B is October 2021.
Okay, October 2021. Okay, sounds good. I don't know. I want to let you know that right now, F1 category priority date is February 2015. Okay? And
I see that.
F2B is November 2015. That means that F2B is advanced than that of F1 category. You see my point?
Oh, okay. Yeah, okay.
So is it
not much difference between those two?
Not only much difference. There's a difference there between February and November. That's March, April, May, June, July. So there's approximately around 9 months difference between February and November of 2015. And guess which one is better right now? It's actually F2B is better right now. You understand what I'm telling you?
Okay. Yeah, I got you.
So now there is another thing for filing purposes though. Seems that F1 category is September 2017 and F2B is January 2017. So there's a whole lot of difference between filing and getting the green card. But you may want to look into if you really want to get the citizenship, you want to delay it, that's up to you. But if you do get the citizenship, I want you to file an I-130 immediately under the F1 category and port the date to F1 category.
Oh, okay. Got you. Okay. So it's the same process, like it's a kind of I-140 and I-130 is the same way. So once we get approved, wait for the dates to current, that's all?
That's right. It's very similar to that of the I-130 and I-140 are exactly the same. No difference. And in this particular category between F2B and F1 category, you can port the dates. Okay, very similar to EB2 and EB3.
EB3. Okay. Yeah, got you. Yeah. Thank you so much, Rahul Garu. Thanks, Nitya Garu.
Thank you.
Thank you, sir. Thank you so much for calling us.
Bye-bye.
Bye, sir. Thank you.
Nitya Garu, the categories in family immigration is family-based 1 to F2A, F2B, F3, and F4. F4 is for siblings, where it's approximate for Indians, the waiting period is approximately around 19 years. But for the F2A, it's about 4 or 5 years. F2B, it's about 10 years. For F1, which is adult children of U.S. citizen, is about 9 years right now. Okay. So when people want to get the citizenship, when they file F2B category, that means their children about 21, they need to look into, do they really want to move them to F1 category, or they still want them to be an F2B category? If they want them to be F2 category, because sometimes, or most of the time, F2B category is more advantageous than that of F1, they may not want to get the citizenship so that the kids can get the green card faster.
Correct.
They need to calculate it. Is it worth for them to get the citizenship? We'll go to the next person.
Also, sir, has there been any update on, this not having the kids age out?
No, there is no update. No update right now from the Congress now.
Okay. Yeah. That's indeed sad, because I feel it's an unfair thing to do when
right now they are in the election mode, and this whole year will go with election mode right now. We're in March, November is coming. So once the November crosses, especially in the lame duck session that we call after the election is over and before the new Congress comes in, that's where we see all these bills coming up.
Okay. All right. Fingers crossed, guys. Come on. Let's start our praying and let's hope this thing comes through. All right. And on that note, let's take our next caller. Okay. Caller with number ending in 0880-0880. We're ready for you now. Hello?
Yeah, hi. Can you hear me?
Hi, sir. Yes, we can hear you, sir. Thank you so much for calling us. Go ahead with your question, sir.
Yeah, thank you. Thank you so much. So I have two questions. Actually, my priority date in EB2 is March 2015. And my son is already in the college of first year. So he is 18 years. So I have two questions. One is like when I can just move him to F1, because with the current situation, I don't know when I will get EAD or green card.
Of course.
That is one question. And second question is like, if I move him to F1 now, can I bring him back to H4 later, like if I get EAD? So,
okay. Yeah, here is a question. First of all, if you move your child to F1, the most of the parents' fear is, hey, if the priority date becomes current, can I add him to my green card application? Or will I lose that opportunity of getting the green card when the priority date is current? The answer is simply, if you move into F1, you can always add him to the 485 application. The kid does not have to be on H4 application, H4 to get into the 485. Of course, he has to meet the requirement. The child has to be under 21. And you know that there is a CSPA 21 age. It's a little bit different than that of the 21. You might have already known. But the child has to be under 21 and the CSPA to file. He does not have to be an H4 to add to your application. So be free to move on to F1. You can always bring him back to the adjustment of status. Next question. Is it worth right now for him to move to the F1 right now, or should we wait until he becomes 21? There are some disadvantages and advantages. If we move to the F1 right now, and everybody knows that they have to move to the F1 before they become 21. I don't have to explain that. But is it worth, because the child is only 18 or 19 right now, is it worth right now to move him right now, or should we wait? Now, check, especially if he's wanting to take some internships, want to do some jobs, some things related to employment-related things where he wants to do it, though. He cannot do it on H4. So I would strongly recommend to move on to the F1 visa. That's one thing. The other thing is that there is a requirement the person has to spend a certain time on F1 visa to get the OPT. The OPT is given after they graduate the degree. So if you in the final semester, if you get the F1, he may not be eligible for the OPT. So be careful on that one. I know for sure that if he completes 2 semesters on F1, then he is eligible for the OPT. So be careful on that part too. Okay. So because otherwise he will lose the OPT opportunity. And there is premium processing available F1. There is premium processing available, and there is change of status. That means that he can apply the change of status from H4 to H1 within United States, or he can go outside the country to get the stamping. I strongly recommend the kids who have done the high school here in United States to apply for the change of status application here in United States instead of going outside the country and getting the stamping. The main reason is that when you go outside the country, they have to prove that they are going to return to their home country once they complete their education. Now, some of these kids that graduated in the high school here in United States, they don't even know what their home country is. When I speak with them, I'm going to return to home country. I lived all my life in Texas. I'm going to return to Texas. Oh, buddy, that's not your home country. So they get confused on that. And sometimes it may cause rejections for the F1 visa, especially when there is a lawyer. If there is any RFE, you can always engage a lawyer at that point of time, and the lawyers can respond properly. So kids may not be able to articulate their things much better when they go to counseling. So think all these things and make a decision, okay?
Yeah, sure. Thank you so much for the details. Actually, he is in first year of college and he got a couple of employment opportunities, but because of work authorization, he is losing.
Go for
F1,
thank you so much. And then you can do premium processing.
Yeah, sure.
Thank you.
Very easy. Thank you so much. Thank you.
Thank you, sir. Thank you so much for calling us.
Nitya, especially for the people to graduate in the degrees, though, if they are employed a certain period of time in their relevant field, their opportunity to get the jobs, their opportunity to pursue a certain profession will go very high. And especially the H4 kids lack that opportunity because they cannot work on a H4. They cannot do internships on H4. There are a lot of limitations that they have, though. So kids need to, children and the parents need to see when they want to move their kids. For example, this particular kid is losing the opportunity of working on H4. They should move to the F1 visa.
Okay, that makes sense, yeah. Rather, on a similar sort of with the kids question, I have one on the live chat. This is from Madhu. It says, my daughter is a US citizen and will turn 21 in 5 years. Can I apply for citizenship through my daughter? My husband is on H-1B and green card process is not started yet.
The answer is yes, of course. You can wait for the child to become 21. However, I don't know how long the husband's H-1B is valid. What if the husband has an H-1B from past 3 years? And how many years he has left for him to get for him on the H-1B? Only 3 more years. After that, the person has to leave the country. So Madhu, I would advise that your husband file the green card in the employment-based immediately for a lot of things. Maybe green card is not the only thing that you get by applying the green. He will get the H-1B extension beyond 6 years. Also, if you are an H-4, Madhu, you will be eligible to get the EAD if your husband gets an I-140 approval. So these are the 2 great advantages. I want your husband to file the green card right now. But of course, if the child turns 21, voila, you file the green card and you get the green card. That's definitely better and easy way. But still don't forget that H4 EAD and H-1B extension is not possible unless your husband files the green card.
Got it. Sir, it's so funny. They allow kids who are 16 to drive, but they cannot sponsor their parents.
Yeah.
Which is a lot less dangerous compared to driving.
Yeah. Well, right now, if the Trump comes in, we don't know what he's going to do now. It has to go to the Congress, though. If the Trump definitely wants to remove these kind of green cards, though, where children can file for the parents, though. However, he cannot do it unilaterally. It has to go to the Congress, which most probably is not going to approve them. But I'm just warning what the at least the 50% possibility, as you know, we're not to politics. We see that Republican nominee most probably is going to be Trump, and then Democratic nominee is going to be Biden. So there's 50% probability that Trump may become the president.
Okay. I think both options are scary right now for me, but you know, on that note, there's one other question that I'd like to address, Andy. This is from Chandana Yeruvaka, says, my passport is expiring April 26, 2026. My renewed H-1B petition is expiring July 23rd of 2027. Visa stamping expires July 2024. And I'm traveling to India on April 20th to April 30th of 2024. What will be the admission date on my passport at port of entry? If I want renew visa stamping in India, how can I renew H4 without filing 539?
So first thing is that,
okay.
First thing, you can go and get the stamping then. The stamping will be given until 2027. For the main H-1B applicant, it will be given until 2027. For the dependent, it will be given until 2027, July 23rd, 2027. But when you enter into United States, though, the I-94 validity, that means the permission that is given for you to stay in United States based on the I-94, may be limited to the passport expiration, which is April 26th of 2026. You need to watch that. And if that happens, though, because your I-94 is expiring in April 26, 2026, and your visa stamping is expiring until July 23rd, 2027, before April 26th of 2026, though, you can always go to Mexico, you can go to Canada, or you can go to India and come back at that point of time. I'm assuming that by that time you will renew your passport and you will go to Mexico, Canada, or to India and come back, and then you will get until July 23rd, 2027. Now, for the H4 stamping, they don't need a I-797 approval. They can always go with the spouse's I-797 approval and spouse's H-1B and a marriage certificate. You show both of those things, they will give the H-4 approval. The spouse H-4 does not need to have the I-797 approval to go for stamping.
Okay. Gotcha. Thank you, sir. Thank you so much for that. And on that note, let's take our next caller. Okay, caller with number ending in 6861. 6861, we're ready for you now. Hello?
Hi, guys. Can you hear me?
Hi, sir. Yes, we can hear you, sir. Thank you so much for calling us, sir. Please go ahead with your question.
Hi. The question is, my and my wife got 485 approved. So is there like any restriction in changing jobs? Like we have to wait like 6 months before we can change jobs or any such restrictions? And what are the steps that needs to be taken after getting a green card with regards to social security and driver's license and I-9? That's the question. Thank you.
Good question. Nice question. First of all, you can quit the job whenever you want to. You can flip a burger in McDonald's, you can be a Microsoft CEO, or you can be a lawyer. Like, absolutely no restriction on the profession, what you want to do. Now, good question is, do you need to go to the Social Security office? Yeah, you can. You can go to Social Security office and take down the restriction that's there, that only valid based on the immigration papers, though. You can take that thing out. I-9, you just have to give the green card to your employer and they will update the I-9 form. Social Security office. Yeah, I already covered Social Security. Driving license, you don't have to go to the driving license right now. If your driving license is valid, whenever you get the renewal, at that point of time, I want you to show the green card to get the renewal. You don't have to do it immediately.
Okay. So just a follow-up question. Like, I haven't signed anything for my employer, so no employer can force me to stay there after getting the green card, right, sir?
No, sir. They can do whatever they want to. You can do whatever you want.
Thank you so much.
Okay.
Thank you so much, sir.
Thank you.
That's all.
All right.
Yeah.
Okay, sir. Thank you so much for calling us, sir. Have a nice day. I love the irony of this, and till we get our H1, till we get our green card, it's like stuck in that rut, and then after that, it's like they don't care if you go flip a burger at McDonald's. So
yeah.
so such a weird thing to fathom and butter. Okay, one quick question, sir. This is from PK Rancho. Says, what is the minimum time a kid needs to be on F1 to get their OPT?
2 semesters.
Oh, 2 semesters. All right. Thank you, sir. And folks, for those who are tuned in, we will be back same time, same place next week. This is our first show on TV9, and we're super excited to see what the future brings us. Rahul Garu, thank you so much for being on the show today, Andy, and for helping all our viewers as always.
Thank you, Nitya. Thank you.
And to all our viewers, please stay tuned. We'll keep posting updates about, the timings, the format of the show and everything. But if not anything else, we'll be back same time, same place next week. Please don't forget to call us, bring us your questions, and come back and spend this hour with us. And we'll try to answer as many questions as possible. On that note, have a wonderful and fabulous week. We'll see you all next week. Bye.
Thank you.